Okay, this is the third part of the curse of co-suretyship. Okay, next part. Co-suretyship through licensing. In America, a person with a name designated in all capital letters is legally classified as an individual. The legal definition of individual is citizen of the United States. 5 U.S.C. 552A, A2. A citizen of the United States must be licensed for almost every activity under the sun, proven by the appearance of its name exclusively on every type of issue of license. License is defined as follows. In international law, permission granted by a belligerent state to its own subjects or to the subjects of the enemy to carry on a trade interdicted by war. That's from Bouvier's 8th edition. As mentioned earlier in this book, the common law is ancient and immutable and predates all codified law, its principles having been established by usage and custom since before recorded history. Based on principles of the common law, no flesh and blood man or woman need obtain the permission of any abstract contrivance of the mind, such as a government, for fulfilling basic needs for survival and keeping his or her body alive. The only way artificial governments can govern and rule over a living, breathing man is by convincing him that he is a subject of another and others far wiser than he in deciding what is best for him, and then administering legalized deadly violence against him should he stray too far from the herd. Making a man believe that he is a subject can be accomplished in many ways, one of which is corruption of the name, as discussed in the first essay in this manual. As a sovereign, your ultimate remedy is in the common law and international law, that is to say, trade, commerce, and exchange with other sovereigns. And when involved in commerce, that is, intercourse of any kind, the greatest power resides in your true name. Of course, anyone can forego these options and pursue remedy in the name of his or her bankrupt citizen of the United States or debtor trade name, which is always welcomed by government, but eminently ineffective in achieving one's objectives. However, as is discernible from the definition of license above, licensing of subjects comes into play when a trade occupational calling is interdicted or prohibited and forbidden by war, as is presently the case in America. Trading with the enemy is defined as the federal offense of carrying on commerce with a nation or with a subject or ally of a nation with which the United States is at war. That's Black's Law 7th edition. Let's look at some definitions. Interdict, to prohibit or restrain authoritatively or forbid. Subject, one who owes allegiance to a sovereign and is governed by that sovereign's law. Black 7th edition. Alright, the Trading with the Enemy Act of October 6, 1917, so that's House Resolution 4960 and Public Law 91, though admitting of the possibility that citizens of the United States could be considered as the enemy when involved in monetary transactions within the United States, also expressly excluded them from such categorizations. In the following passage, C. Such other individuals or body or class of individuals as may be natives, citizens, or subjects of any nation with which the United States is at war, other than citizens of the United States, wherever resident or wherever doing business. However, the Amendatory Act to the Trading with the Enemy Act, also known as the Emergency Banking Relief Act of March 9, 1933, amended the Trading with the Enemy Act at a time when the United States was not in a shooting war with any foreign foe, omitting the clause excluding citizens of the United States as enemies in war and including them as such instead via assertion in following innocuous little passage, quote, by any person within the United States or any place subject to the jurisdiction thereof. Chapter 1, Title 1, Section 1b. By operation of law, all persons or citizens of the United States involved in monetary transaction within the United States were now official enemies of the U.S. government and as such require a license for almost every type of commercial activity imaginable. The above definition of license from Bouvier's Eighth now becomes more understandable. In international law, permission granted by a belligerent state to its own subjects or to the subjects of the enemy to carry on a trade interdicted by war. The fact that sovereign Americans do not qualify as persons within the United States and hence are not subjects to the legislation was not explained for them by the U.S. government in 1933, nor any time thereafter, and never will be. Using the legislation as justification, however, federal and state government agencies launched a statewide campaign to convince all Americans that they needed a license for virtually every activity they were involved in and managed successfully inculcating this stratagem into society over the ensuing decades. Alright, let's read this real quick. There is no requirement in any vehicle code requiring a driver's license for anyone not engaged in commercial activity of the transportation of persons or property for hire or compensation. As to say, cab drivers, bus drivers, limousine drivers, and truck drivers. The code encrypting esquires that write the vehicle code, however, have very cleverly circumvented this non-requirement via the federal definition of motor vehicle. Motor vehicle is a commercial term and signifies that any automobile, motorhome, bus, truck, van, motorcycle, etc., that is registered with any motor vehicle department is a vehicle used in the transportation of persons or property for hire or compensation, and therefore requires a license for its operation, even though the driver, another commercial term, is not directly involved in commerce. He or she is operating a commercial motor vehicle involved in the transportation of persons or property for hire or compensation. Thus, the need for a license, no judge and no attorney and no police officer can identify any section of any vehicle code that requires that a private, for-pleasure automobile used strictly for non-commercial purposes be registered with the state. Registration of a private use only automobile is voluntary. Okay. Let's read this one. The introduction of the need for licensing and the enforcement thereof was instigated over a longish period of time, thereby avoiding mass resistance from the populace. People in California, for example, were not propagandized the need for a driver's license for non-commercial purposes, that is to say for private for pleasure use only, until 1957, 24 years following the Amendatory Act, when the driver license was introduced. The commercial chauffeur license and the commercial operator license were combined into the new driver license, artfully confusing the public over the need for a driver license in order to drive. Alright, here we go. Next section, licensing equals legal liability. When a sovereign American voluntarily applies for, accepts, endorses in his name, and uses as his own a license issued in the all capital letters trade name of his strawman and the party is signing for accommodation because the strawman is incapable of signing and has cemented his status as surety for the citizen of the United States, enemy, debtor, individual named thereon, because every accommodation party is ever and always a surety. It cannot be any other way. An accommodation party is always a surety. UCC 3-419, Note 3, Paragraph 2. The strawman name on the license has neither the hand nor the body required for applying a signature. Another party must perform these acts on its behalf, someone capable of assuming legal liability for the person in whose name the license is issued, an accommodation party. The voluntary act of applying for a license that is issued in the strawman's trade name by executing one's own signature in place of the strawman's is concrete evidence of voluntary assumption of the status of surety. One who undertakes to pay money, one who undertakes to pay money or perform other acts in the event that his principal fails to do so, the surety is directly and immediately liable for the debt. That's Barron's Law Dictionary, 3rd edition, 1991. As asserted by the Assistant U.S. Attorney in the Cooper case, the act of paying Social Security payroll taxes into the Social Security account of the individual named on the Social Security card constitutes a contract of co-surety that places anyone so contracting in the federal jurisdiction and the subject of mandatory federal income taxation. Since the entity listed on every license that you carry is the same as the one on the Social Security card in your possession, there is no reason to believe that the same liabilities do not apply. Next section, volunteering and co-suretyship. The Internal Revenue Code, Title 26, United States Code Annotated, states that our system of taxation is based upon voluntary compliance. As everyone knows from the cavalcade of cases that are enthusiastically reported by the news media, those who do not, quotes, voluntarily comply and file income tax returns and pay income tax are forced into complying and paying with fines, indictments, seizures of property, garnishments, and incarceration. When did the voluntary part come into the picture? Answer: there was no means an exhaustive list, though by no means an exhaustive list. The moment you voluntarily paid into your first penny of Social Security payroll tax, which was of course preceded by your parents voluntarily enrolling you in the Social Security system when you were a minor, and use subsequent failure upon attaining the age of majority to withdraw from the program and nullify and cancel the contract, thereby tacitly consenting with the terms of the contract in full, albeit unwittingly, and making yourself welfare eligible. The first time you voluntarily accepted free home delivery of mail matter from an agent of the Commander-in-Chief, i.e. de facto military personnel of the United States Postal Service. Note, although you can officially notice the postmaster that you have been accepting free delivery of mail matter under mistake and no longer wish to have free delivery, the headaches that come with such a move are significant. Capture of legal title of the trade name under the common law and control of the same through the UCC allows both the use of the Postal Service and control of the destiny of the citizen of the United States trade name. The first time you voluntarily applied for and signed for and paid for and received a license for a privileged activity in the all capital letters name in your citizen of the United States individual, United States government employee trade name, and assumed responsibility for payment and performance of the strawman's obligations associated therewith by citing for accommodation, and the first time you undertook numerous other voluntary acts, such as applying for and paying for and receiving a passport from United States Department of State and registering to vote in the all capital letters Citizen of the United States trade name, and then affixing your own personal signature as the accommodation party and therefore surety on each document. Next section, the situation. The only reason you have suffered at the hand of those who have bled every ounce of economic lifeblood from your withered carcass is because you are unaware of the artificially manufactured justification technique used by such con men for wrecking holy hell with your life, that is the corruption of your trade name. It has taken over 2,000 years, but its little band of extortionists has put together quite an operation for itself, and it all depends on your continued ignorance of the name as personal property and the significance of your true name spelled in all capital letters abbreviated format. The reason the government, bank, corporate, court, and tax agency computers spit out bills, statements, and threatening correspondence with your name corrupted into an all caps format is because the entity named therein is the actual target, the account holder, the customer. They are utterly dependent on your mistakenly believing that the all caps name identifies you, so you will assume the role of accommodation party and surety for the artificial person they have created. Such is the depth of their deceit. Their entire earthly objective, every waking moment of every single day of their hideous little existence, predicated on keeping you and your family and your friends ignorant of the real meaning behind the name set in capital letters, and the significance of applying your own signature when it's the straw man's is required. For those afflicted with the curse of co-suretyship, the pathology can be grim. Loss of wealth, loss of possessions, loss of shelter, loss of family, loss of self-respect, loss of health, and even loss of life. It matters not whether one willingly submits and acts in accordance with the agenda of the chosen masters, and does as one is told. The foregoing milestones comprise the schedule of events for one and all. The only difference is the timing. There is no logic in these plans, and there is the very reason that most people cannot conceive that anyone else could have such evil intentions. However, if unchecked, everyone, including the perpetrators, will lose in the end. Probably the most tragic and regrettable fact of all is that one of the statements contained in this volume constitutes hyperbole. Your authors wish it were not so, but such is the gravity of the situation we are faced with. Alright, next section, relief. No matter how black it may be for some, there is abundant hope for those who are capable of seeing what is in front of them. For such people, the curse of co-suretyship is as temporary as the common cold and more easily treated as well. Capture and control under the common law of the trade name that others have been exploiting at your expense requires nothing more than asserting that fact in writing, taking the steps of filing the statements in the legal notices section of the newspaper, and with the county clerk recorder establishes public notice and makes it much better. Following public notice of your new common law copyrighted trade name, creation of the legal relationship between the two of you via the private agreement and a security agreement, and execution and filing of a UCC financing statement to perfect the matter can be completed in days. These documents legally distinguish you from the trade name and give you legal control over it in all financial and legal matters, including those involving government actors who carried out the ugly plot at the behest of chosen masters that put us in this mess in the first place. The degree of control over your economic life depends only on your understanding of the power that resides in legal ownership of your true name and trade name, and your effectiveness in communicating it. Mere notification of the relationship between you and the trade name is sometimes sufficient to stop a would-be predator. For others that require more persuasion, the material in the presentment handling section will take care of the vast majority. For the minute percentage that insists on kicking and screaming every minute or every step of the way until closure, the publisher can suggest other contracts that can assist you in your needs. Full speed ahead. All right, and from there we will start the section 4, annotated glossary of terms.